Hello, friends. This is Bonnie Harris Hayden. I'm back again, doing a wonderful video for you. I'm so happy to tell you today about estate planning, to do an overview of estate planning. I am an estate attorney, been one for, oh my goodness, 15 years now in California, and I am very lucky to do charitable estate planning for the American Heart Association. And so today, my mom is going to be you. She's going to be the audience and ask some questions to forward our conversation, because I know you would be asking some of these questions if we were able to be face-to-face together. And so my mom is Judy, and we're going to just do, again, a wonderful overview of estate planning for you that I hope you find very helpful. So, Mom, do you want to start us off with the first question?
Sure.
Okay,
what is estate planning?
well, estate planning is when you get your affairs in order, when you create some documents that help you provide for your family and for your family's security and for your own security in case something should happen to you and you're not able to manage your affairs. And you can also put instructions in these documents so that your loved ones or your trustees know what you would like to do with your estate when you pass away. So that's estate planning. And then there's other components to it as well, like if you have to deal with estate taxes, to do a little tax planning, things like that, that can also be handled in the documents that you do with your estate attorney. So, yes.
So now we're going to talk about the documents.
Yeah, we're going to talk about the documents. I mean, I think right before we talk about the documents,
Yes.
some people say, well, I don't have very much. I don't have an estate. It sounds kind of grand, you know, like you kind of think about maybe Gone with the Wind or something, and it's a big giant house, and maybe you don't have that. But
And a lot of money.
well, yeah. But in California, if your estate is worth over, your assets are worth over $162,500, you could probably benefit from some estate planning, because those assets might fall into probate if you don't do some planning. And so probate is when the court supervises the distribution of your estate, and it is very cumbersome. As you can imagine, the courts are quite backlogged, and your executor, who would have to take your estate through probate, is going to have to file all sorts of documents, accountings, get an inventory and appraisal, all kinds of things. And so if you do estate planning and you take your assets and you put them into a trust, then you won't have to have a probate, and your family won't have to go through a probate when you pass away. And so that's really one of the main reasons why we do estate planning in California. So who needs it? Pretty much anyone who owns property in California, since we all know real estate prices are so high these days. And then depending on kind of other assets that you might have. So yeah, we don't need to have a giant mansion or lots of money to benefit from estate planning.
That sounds good to me.
Yes.
Okay, so now we can go to the documents that are in an estate plan.
Sure.
That would be helpful.
Yes, so some of the documents are going to be in every single estate plan. And the estate plan that's kind of what we call your entire package of documents that you get from your estate attorney. So some of them are going to be in every single estate plan, and then depending on who your estate attorney is, there might be some different documents than someone else, or some additional documents depending on your situation. And so let me just kind of explain. It's sort of like making chicken soup, right? There's how many recipes do you think for chicken soup in the world? Thousands.
Many.
Probably, right? But they all come out to be chicken soup. And to make the chicken soup, you need chickens, chicken broth.
As a matter of fact, I made some last night.
Okay, well, I need to eat some of that. But so we need. There are some things that are going to be in every single recipe of chicken soup: chickens, chicken broth, things like that. And then maybe, depending on who you are, who the chef is, maybe you'll put in some carrots, maybe you'll put in some celery, maybe you won't, right?
Matzo balls.
Okay, so matzo balls. So estate attorneys are the same. There are some documents that every single estate attorney is going to put into your estate plan, and then there are some that are going to be a little different, but it's all going to come out to be chicken soup,
Okay.
Okay, so the main document that we talk about for an estate plan is a revocable living trust. Do you have any idea what a revocable living trust is? Have you heard of that?
Yes, I have.
Yeah.
And I have one.
Yes, she does.
It was created by a very good lawyer that I know.
Okay.
Mm-hmm.
Yeah. So revocable living trust is an entity that's created, a legal entity that's created, and it's kind of like a bucket, and it holds things. And so you have to transfer things into, you have to put things into it. And so, for example, if you create this revocable living trust, you would do you or your attorney would do a deed transferring your house into your trust. You might rename some of your accounts into the name of the trust so that it's holding these assets and protecting them from probate. It's revocable, meaning you can change it or you can completely cancel it, dissolve it, undo it, you can amend it. And it's a living trust in that you're making it while you're still alive, and you have to be competent to do it. So sometimes the trust isn't changeable if someone, for example, ends up with dementia or Alzheimer's, something like that. So as long as someone can still think and function, they can change their revocable living trust. That's the main document that's going to keep assets out of probate for California. And there's probate in every single state. So it's not like you can't have these trusts. You can have these trusts anywhere. But the probates in each state are different. And some are quite simple and some are quite complicated. So so another way that you could also avoid probate is if you hold property in joint tenancy. So a lot of husbands and wives own as husband and wife as joint tenant on your deed that you see. If it's joint tenants, it says where the property is supposed to go after the first person dies. So you don't need to have a court say, well, this is where it's supposed to go, because it's clear where it's supposed to go. The problem with holding things as joint tenants is what happens when the second person passes away. Then where does it go, right? So it's still a really good idea to put your property in a trust, because the trust will provide the instructions of where everything is supposed to go when the second person passes away. Another way to avoid probate that isn't your trust is also beneficiary designation. So when you have a life insurance policy, for example, you fill out one of those forms and you write your beneficiary on it. Well, the court doesn't need to sign off on that because it's very clear where that's supposed to go. So those types of assets, beneficiary designated, they don't need to go into a trust. But your bank accounts, your brokerage accounts, your real estate, very important to put into a trust. And then other accounts, like you could designate a beneficiary on a checking account or a savings account. You could do that. You should designate beneficiaries on accounts that are able to do that. That would be helpful. And sometimes you can even designate your trust as the beneficiary or backup beneficiary. So that makes things a little easier too.
Oh, okay.
So that's your trust. And it's your bucket holding everything. And that's going to be in pretty much every estate plan. And then another document that's going to be in every estate plan is a will. And I know that sounds kind of weird, right? Because a lot of people ask me, well, if I have a trust, why do I need a will?
Well, what is the answer?
So the reason that you need a will is the will is what's called a pour over will. And it says everything that I have pours over into my trust. Everything I have is supposed to go into my trust. So just in case something didn't make its way into your trust, like if you bought a second home for some reason, a vacation home or something, and you forgot to put it into your trust and then you died, there would be a probate of that home, and that will would say, well, it was supposed to go in there. And so that would make the whole probate process much easier. So that's why we have a will. It's only going to be used if something didn't make its way into your trust. So hopefully you wouldn't even need to use it. The only other reason you need to use it in California is to designate guardians of minor children. So if you have minor children, you can't designate the guardians for them in a trust in case something were to happen to you. You have to do it in a will. So you're going to have the trust, and you're going to have the pour over will, and then you're going to have powers of attorney.
Oh, yes. Yes,
powers of attorney. And so there's really two kinds of powers of attorney that pretty much everyone should have in their estate plan. And that's going to be your medical power of attorney, right? Which is also called Advanced Healthcare Directive. And we actually have talked about that a little bit before. And so that power of attorney only comes into effect when you're alive, but you can't take care of yourself for some reason. You can't make medical decisions for yourself. And so you designate someone to do that for you in that document, and the doctors can refer to it, and it has all of your instructions in there about what you would want to happen to you if you got sick or in an accident or something like that. So that one's really important. So it's either called Medical Power of Attorney or Advanced Healthcare Directive, same thing. Another document in California that people use is also called 5 Wishes, and that's sort of another format of an advanced healthcare directive, and it is legal. It's a little bit different, and it's not as widely recognized. It's newer, so I still recommend just getting an advanced healthcare directive. And then your other one is going to be the financial power of attorney. So the financial power of attorney says if you're not able to make your own decisions, who's going to take care of your financial matters, who's going to write the checks to pay the water bill, and who's going to go to the bank, and who's going to make investment decisions and things like that.
Yes.
And so those 4 documents are really the base of the chicken soup. The revocable living trust, the will, the medical power of attorney, and the financial power of attorney. Those are basically in most, if not all, estate plans. And then there's other documents that might be a part of an estate plan as well, depending on your situation and how your attorney likes to do things and what needs you might have. So that's kind of what those documents are, and they each operate under a little bit different circumstances. Your will, for example, only comes into effect if you already passed away and you didn't put something in your trust. Your trust can operate when you're alive and when you've passed away. And your powers of attorney are for when you're still alive, but you can't take care of yourself. So that's why we have so many documents, because lawyers like to charge by the page, right? No, we have so many documents because there's so many situations that we want to cover. So, yeah.
Okay, but what do they do? The documents, I mean, you describe them in very nice detail.
Thank you.
Yes, well done. But like, do they avoid taxes? I mean, there's a number of things that, could come into play that these documents are important for.
Yeah, so these documents definitely help to avoid probate, like we discussed. So because of these documents, you won't have to have the court supervise the distribution of an estate, or because of your powers of attorney, for example, if you got sick, the court would not have to step in and appoint a conservator for you. The power of attorney already says who's supposed to take care of you. Mm-hmm. And so, I mean, it's really nice, I think, to keep the court out of things, especially because the fees for probate are mandated by law. And so you don't get to just your family doesn't get to just shop around and find the best deal with an attorney. The fees for a probate are a percentage of the estate. And there's no choice about how much those are. And a probate in California takes between 2 and 3 years now.
Oh my.
Yeah, even if nobody's fighting and there's no glitches, because everything's just so backlogged. So your family would have to wait all that time before they could get their gifts from the estate. And you don't want that tied up for so long for them, right?
Right.
So that's another reason why we do these documents and what they do. What they do is to streamline the process of not only distributing your estate and doing it according to your wishes, because they're really your instructions about how to do that, but they also help to take care of you when you can't take care of yourself. So, and they give people in your life power to do what they need to do as if they were standing in your own shoes, as if they were you.
Mm-hmm.
Then they can act and do what needs to be done for you.
Is there an estate tax?
Yeah, there's an estate tax, but not in California. So of course there's so many taxes, right? There's estate tax, gift tax, income tax, there's California tax, there's federal tax, there's so many taxes. So be sure to please talk about your finances and your assets and your situation as openly as you can with your attorney so that they can help you if you need any tax planning, because they're not going to know what you don't tell them, right? Mm-hmm. So the taxes, there's no estate tax or death tax in California. But there is a federal estate tax, but that estate tax, it doesn't even kick in unless your estate's worth more than $11.5 million, or what is that, $23 million as a married couple. So most people, so that means there's not going to be estate tax to pay unless your estate is worth more than that. However, we all know we just had an election, and when elections happen, laws change. And estate tax exemption amounts can change and could go down. And so we just don't know how long the levels of the exemption amount are going to be that high. And so you should still be careful and do a little tax planning because the laws change. And who knows if there could be estate tax, they might drop the exemption amount down to 5 million or 2 million or who knows, right? So talk to your lawyer about that. Yes.
So there are various people who are involved in doing estate planning. So could you kind of tell me what their positions are and who you should choose to do them?
Yeah, so in the documents that we just talked about, there's 3 different positions, right? In your trust, the person who establishes the trust is the trustor or the settlor. That's you. You're establishing your trust. Then the person who administers it is the trustee. Now, while you're alive and willing and able and capable, you're the trustee as well. You're both. You established it and you're administering it. But if something happens to you and you can't take care of yourself, then you have someone as a successor trustee, a backup behind you. Mm-hmm. And so that person is really going to be dealing with financial matters. They're going to be dealing with all the assets that went into your bucket, into your trust. So choose somebody who is good with money. Okay, choose someone who knows what they're doing when it comes to money, if you possibly can. Someone who you trust, and that may or may not be your child or children. You can have co-trustees if you'd like. Just make sure they don't fight, because then nothing will ever get done. So you can do that. You can ask your CPA. You could try and ask your financial advisor. Sometimes they don't do those things because it's a big responsibility and they might not want to take that on. Mm-hmm. But just someone who you really trust with finances could to be the trustee. Your executor, kind of like we discussed, is a person who's designated in your will to take care of things after you've passed away. And that's, again, going to be financial. It's still going to be dealing with an asset that didn't make its way into the trust. Mm-hmm. So it could be your trustee and your executor can be the same person because they're dealing with the same thing. And then your agent for your power of attorney for your finances, same thing. Power of attorney for finances, dealing with finances. So that agent who's going to be making decisions about financial matters while you're healing from something or sick or can't make decisions for yourself, they're going to be dealing with your finances and your assets as well. So that could be the same person, but then when it comes to your agent for your medical power of attorney, your medical power of attorney person, that person might be totally different than your financial one. Maybe your son is really great with medical decisions and keeps a really cool head about him, and maybe your daughter is a CPA, and so you want her to do the financial decisions, so those positions can be different, and they can be the same. And again, you can have co people do it as well, 2 people, 3 people. Just know though, if there's a disagreement, better to have 3 people so there's a tiebreaker. But just people that you really, really trust, and literally trust with your life, who will not fall to pieces and can execute your wishes if something happens to you and you're in the hospital, So those are the different positions: trustee, executor, agent, and think about it carefully. And you can also pick backups to those agents. So if you pick your son, but then what if something happens to your son, you can pick your nephew or your niece or your best friend, or you can really choose whomever you like as long as you feel comfortable with that choice. And if you don't have anyone in your life that you really care to designate for these positions, you can hire what's called a professional fiduciary, and those are people who are actually licensed to do this kind of work.
Oh.
Yes, and they are regulated and licensed, and they know exactly how to administer an estate and take care of things if something happens to you. And so you can use a professional fiduciary. You can also do a corporate fiduciary, which is a big company that takes care of these things, like Northern Trust, for example. But corporate fiduciaries usually have a minimum that your estate needs to be worth before they'll work with you. And some people don't meet those minimums. So a professional fiduciary is just an individual person that does it, and they don't usually have a minimum.
Mm-hmm.
So that's who you can get to do these things.
Good.
Yeah.
Well, as I said, I have a very good estate planning attorney. But how would someone else go about choosing an estate planning attorney?
Yeah. So when you're looking for an estate attorney, definitely think about your goals, what you have in mind, because some people say, look, I don't really care about the personality of my attorney, I just want them to know what they're doing and draft the documents. Some people really want their attorney to have a good bedside manner and want someone who can spend some time with them and really answer questions for them and really explain how the document works and really work with them. And so just like a doctor, you want a lawyer that has a good bedside manner that complements you, because you're going to be working together for a while. This process could take a few weeks up to a few months, and you should like the person that you're working with, and you shouldn't have to feel concerned or scared if you have questions. Sometimes it's a little intimidating to call your lawyer and ask questions, and so just find someone that you're really comfortable with, that can make the process as good as possible for you, depending on your personality and how you want to work. And then you should also check with your attorney, and you have to see, shop around. This is a really important decision. So first of all, see if the attorney will give you a free consultation, and then also see how they charge. See if they charge a flat fee for the whole package of documents, or see if they're going to charge you hourly. Usually it's a flat fee in California, and the fee depends on sort of where you live a little bit, and also your estate, how complicated and how many assets you might have. So just ask them if they charge hourly or a flat fee, and see what the retainer is like, and just try and get a sense of if you like this person and how to work with this person. So, and then just ask several people, because you're probably going to know this person for many years, and so you might as well like them. Yeah. So, do you have any? Is that it? Do you have any other questions?
I don't know. It's pretty clear cut to me, but maybe there's something you can think of that you haven't. That you haven't mentioned.
No, it's just, we're just giving a very brief overview today. As you can imagine, it can be more involved, and there's more documents that could happen. See if your attorney will do the deed, transferring your house into your trust. Some attorneys don't do that deed for some reason. I think that they should. It's part of your estate planning. Kind of figure out how thorough they are, and then there's going to be other documents that might be part of your plan as well. And so, so that's important. But I would just say, if you need anything, you're also welcome to contact me, and my contact information is going to be at the end of the video, and you're always welcome. As a service that the American Heart Association provides to you and to the community, you're always welcome to ask me questions about referrals to estate attorneys in your area, review of your documents, getting you ready to go see an estate attorney. You can pick my brain anytime, and we just really want to thank you for taking the time to watch this and have us share with you, because we know that this is a very interesting time in the world, and the great work of the American Heart Association continues on doing COVID research, doing cutting edge research for heart disease and stroke, and helping people have more time with their families and better quality of life and health. And so our work still continues, and we're so happy to give back to the community in providing this kind of advice and information and service to you. So thank you so much. You are welcome to contact me, Bonnie Harris Hayden, anytime at bonnie.hayden@heart.org, or you can call 1-888-227-5242 and ask for me, or you can also go online and create your own will for free at www.freewill.com/heart, and it's free and confidential. And if you have more questions about estate planning and all the different ways that you can do gifts to charity through your estate, you're welcome to go to www.heart.org/plannedgiving. Thanks.